Hello friends, in the series on the income tax cases, today we will discuss a very important issue for those charitable organizations who are claiming the exemption under section 11. Prior to 1st April 2021, the provisions of claiming exemption under section 11, 12, 13 were complex, and after 1st April 2021 these provisions have become more complex due to various amendments which were very difficult to digest even for the professionals. And the flavor to the misery of the assessee has been added by the CPC by passing the intimations under section 143 subsection 1 even for the minor lapses on the part of the assessee and taxing the whole gross receipts of the assessee. The question before the Honorable Madras High Court in the present case was that if the assessee is not registered under section 12A but claims exemption under section 11, and in that case if the assessee got the exemption from subsequent year, so whether the whole income or the gross receipt of the assessee can be taxed just because that the assessee has not filed the return of income as a regular assessee or as an association of persons on time. This critical and important issue has been taken up by the Honorable Madras High Court in the case of Sree Venkateswara Educational Trust versus Income Tax Officer. This case is reported in 479 ITR at page number 687, and the date of the judgment is 2nd September 2024. The assessment year is assessment year 13-14 in the present case. The assessee was an educational trust. There was no doubt about this fact. The assessee filed the return of income for the assessment year 13-14, and the assessee was not having the registration under section 12A for that year. So when the CPC examined this fact through the machine process, a very casual intimation was sent to the assessee by taxing the whole receipts of the assessee. But after that the assessee got the registration from the next year. On the basis of the registration in the next year, the assessee filed rectification application under section 154 that my whole income should not be taxed. But that rectification was not allowed by the assessing officer. So the assessee filed the appeal before the CIT appeal. At the first time, the assessee before the CIT appeal was contesting that even if I am not entitled to section 11 exemption for the relevant year, but the normal deduction of expenses should be given to me as if I have filed the return of income as a regular assessee or as an association of person. But the CIT appeal denied the appeal of the assessee, and similarly the tribunal was also of the view that the assessee is not entitled to section 12A registration because the assessee was not having the 12A registration in that particular year. And the tribunal also said that since the assessee has not filed his revised return on time, then in that case the assessee should not be allowed the deduction of the normal expenses. This was the view of the tribunal. So when this matter came before the High Court said that to the extent that the tribunal has said that the assessee should not be allowed the exemption under section 11 for the year for which section 12A registration was not in force, up to that point the order of the tribunal was correct. But the assessee could not be denied all the legitimate deductions from the gross receipts just because of the reason that the assessee has not filed his return of income as a regular assessee or as an association of person. The High Court said that only the just tax can be collected from the assessee by doing his assessment, and unjust tax cannot be collected from the assessee by holding that no return has been filed by the assessee as a regular assessee or as an association of persons. The court said that simply because the revised return has not been filed on time, the other deductions cannot be denied to the assessee just on the ground that the return has not been filed on time. And the court also said that in the present case, the last date to file the revised return was 31st March 2015 and the intimation to the assessee by CPC has been issued on 12th March 2015. So in that case, the assessee was having very less time to revise that return. So the High Court remanded the matter to the assessing officer back to allow the assessee all the regular deduction by examining the various facts of the assessee. Friends, this case is very important. This case is applicable to a number of the cases where just because one or the other reason, whether the return is not filed on time, whether the form 10 is not filed on time, whether the 10B is not filed on time, all the deductions have been denied to the assessee and all the gross receipts has been taxed. But only the misery adds to the assessee in these type of remand back that now the AO will examine the expenses. If the assessee would have filed the revised return on time, so his return should have been processed in a normal way and he has not to face the scrutiny. But since it is a remand back matter and the AO has every right to examine all the vouchers, all the expenses, so it will be a regular assessment type remand back to the assessing officer. At the end of this video, once again I am repeating the name of the case. The name of the case is Sree Venkateswara Educational Trust versus Income Tax Officer, and this case is reported in 479 ITR at page number 687, and the date of the judgment is 2nd September 2024. Thank you, friends.